It is a form of self-gratification by which municipalities announce their supposed virtue on the issue of free immigration, unless and until they are overwhelmed by actual immigrants, in which case, as has happened in New York, where local authorities have said, forget, we're not doing this anymore. But no state has the power to exempt itself from the Supremacy Clause. We settled that in the 1860s during the Civil War. If people are confused, they're not really trying, Andrea. There simply is no issue. Ironically, the Supreme Court in the last 15 or 20 years, especially during the Obama administration, very, very firmly came down on the side of the federal government as the sole enforcer of immigration law, really taking out of the states any ability to protect themselves against foreign invaders, especially border states. So, what's good for the goose is good for the gander. I think right now, the tactical problem for the administration is these pockets of judicial resistance. The Ninth Circuit clearly has not yet gotten the message. And the Ninth Circuit used to be the worst. Now the first is the worst. There are still panels that can be put together in the Ninth Circuit, though, that come up with some really bad decisions, like one last week that the administration is obviously going to have to address immediately. There are still really, really bad judges out there, and that's going to have to be sorted out. But the issue of federal supremacy under the Constitution is settled, as is the ability of the federal government to use force, and under the Insurrection Act if necessary, and also not under the Insurrection Act, under the president's fundamental constitutional powers as commander-in-chief. There's really nothing the states can or should be able to do about it.